So good evening. Good evening. I would like to welcome you. I'd like to welcome you tonight to our Dorothy L. Thompson Civil Rights Lecture Series event. My name is Brent Manor, and I teach in the History Department here at K-State, and I'm part of the university committee that helps organize this lecture series. In 1994, the Provost Office established the Dorothy L. Thompson Civil Rights Lecture Series as a forum for discussing contemporary debates and historical perspectives on central civil rights issues. The series promotes intelligent discussion and civil discussion for both the university community but also for the wider Manhattan community. The series stands as a memorial to Miss Dorothy Thompson, who served as the director of the Office of Affirmative Action from 1972 until 1985, and then as the Associate University Attorney from 1985 until 1992. Dorothy was a role model for attorneys in Kansas, highly regarded by people of all political leanings for her diplomacy and for her effectiveness. I've been told that one of the keys to her effectiveness was her wonderful sense of humor, that this could break the tension in the room and allow people to talk in a civil and even fun manner. The committee that organizes the lecture series involves staff from the university, faculty, and even several community members. And our chair this year, the chair of the lecture series this year, is Michelle White-Godinez. If she would stand for a second. And then I'd also just like to recognize the other members of the lecture series committee and also the patrons who help support the lecture series with financial donations. So if our patrons and organizing committee would also briefly stand, we could thank them. And then I just wanted to make one procedural comment before we come to our program, and that's when Professor Robinson is finished with his talk, we'll take a brief little break. There's refreshments will be served, and we'll send out little index cards. And if you have a question about the lecture or an issue that you'd like to engage, please put that on the card, and then I'll be happy to read some of those questions for Professor Robinson, and we'll get his input on those. So now please join me in welcoming the Provost, April Mason, who will introduce tonight's speaker.
Well, it's really my honor to welcome all of you this evening to this wonderful event. We are in for a treat this evening to have the opportunity to hear from Washburn Law Professor Reggie Robinson. Before I introduce our guest speaker, I would like to recognize three very special guests that are with us this evening. And we're truly privileged to have three Kansas Court of Appeals judges who have held court here at Kansas State University today. And as I say their names, would they stand and remain standing so we can recognize them? We have Judge Patrick D. McEnany of Overland Park, Judge Anthony Powell of Wichita, and Judge Steve Lieben of Fairway. Thank you, all of you, for being here. We had a wonderfully engaged dinner conversation with our three guest judges and want to thank them for participating here and engaging our students with their activities today. Before joining the faculty of Washburn University, Reggie Robinson served as the president and CEO of the Kansas Board of Regents from October 2002 till June 2010, and that's where I had the opportunity to first meet Mr. Robinson. He also served for 4 years as Chief of Staff to the University of Kansas Chancellor and visiting associate professor in the University of Kansas School of Law. Prior to his academic career, he was a White House Fellow with the U.S. Department of Justice in 1993, serving as Special Assistant to Attorney General Janet Reno, Deputy Assistant Attorney General for the Office of Justice Programs, and Deputy Associate Attorney General of the United States. His work as Deputy Associate Attorney General of the United States included a key advising role on environmental, civil rights, and justice program matters. So I think you already see the credentials that Mr. Robinson brings here tonight. He received his bachelor's degree in 1980 and his Juris Doctor in 1987, both from the University of Kansas. Prior to attending law school, Professor Robinson served 4 years as a field artillery officer in the United States Army and was honorably discharged at the rank of captain. Currently, he is the director of the Washburn University School of Law Center for Law and Government, where he is actively providing expert assistance to state government agencies. Professor Robinson is an extremely popular instructor at the law school. His classes are well attended, and in fact, the students voted him Law Professor of the Year after only his second year at the law school. Last month, Professor Robinson was one of 3 legal experts to be invited to draft questions for the state Senate to use in the first ever Senate confirmation hearing of a nominee for the Kansas Court of Appeals. The chairman of the Senate Judiciary Committee said of Professor Robinson and the 2 other experts, "There are not 3 brighter, more qualified legal minds in the state of Kansas." We are indeed fortunate to have with us this evening Professor Reggie Robinson, and his talk is called Supreme Court Reconsiders Voting Rights Act, Broken Law or Broken Promise. Would you help me in welcoming Professor Reggie Robinson?
Good evening. April, thank you for that introduction. Planning Committee, thanks for your work and for giving me the honor of delivering this lecture this evening. I've had a great opportunity to work with so many representatives of the institution as the planning for this event has unfolded. It's great to see the judges here. It's great to see former Governor Carlin here. And it's great to see just lots of K-State friends that I've made over my opportunities to interact with this great institution over the number of years, particularly during the time I was with the Board of Regents. But most importantly, it's so wonderful to see so many students here. And I really appreciate you all taking time out of what I know is a busy back-to-school schedule to listen to some thoughts that I have to share with you tonight, and hopefully to throw some questions my way at the end of this presentation. So thank you all for being here. It's a special pleasure to be here under the auspices of an event that bears Dorothy Thompson's name. I think all you have to do is take a quick look at the back of the program that was handed out in connection with this evening's event to get a sense of the wonderful contributions that she made to this institution and to this state. And it's a special pleasure that her husband, Chuck, is here tonight. So welcome and thanks for being here. I really appreciate it. Questions, issues related to voting rights have occupied a pretty prominent place in the media over the course of the last several months. We've seen voter ID legislation pop up around the country, including in Kansas. We've seen new rules related to voter registration pop up around the country and in Kansas. And we've heard and seen all the controversies associated with those legal changes. In addition, and this is what I'm going to focus on, there have been 2 really important Supreme Court decisions over the course of the last 2 months with regard to voting rights that have been announced. The first, which I'm not going to talk about, but I'll throw it out there because you may have questions about it afterwards, is a case that came out of Arizona that related to registering voters to participate in the federal elections and whether states can impose upon on top of the federal requirements, state requirements that are aimed at documentary proof of citizenship. In this case out of Arizona, the Supreme Court held that federal law preempted state law, and states could not layer on top of what's asked for in the federal form requests for additional documentary information with regard to citizenship. that has implications for current law in Kansas that I'd be happy to talk about if folks want to after. I didn't want it to be the centerpiece of my talk. It's a 7-2 decision, so it was a slam dunk on the law. Not that interesting to talk about as a legal matter. It has implications for Kansas, but pretty straightforward as a decision. But again, I'm happy to talk about it if folks are interested in it beyond what I've just said. So I did want to mention it because it does have implications for what we're doing in this state. The second case that I want to actually spend more time on is a case called Shelby County versus Holder. In that case, the Supreme Court invalidated a key provision of the Voting Rights Act of 1965, a statute that has been in operation now for nearly 50 years. It's that development, the court's decision in Shelby County, that I want to talk with you about. And here's what I hope we'll do over the course of the next few minutes or so, or the time of my talk. First, I want to briefly talk about the historical context that gave rise to the Voting Rights Act of 1965. I think that's especially important since we have so many students here who are totally unfamiliar with that historical context and that historical framework. It's an important framework. Second, I want to sort of quickly outline the workings of the Voting Rights Act, particularly the pieces that were the subject of the court's decision in Shelby County. We need to have a sense of how those provisions operated to understand the power of the implications of the court's decision to invalidate those provisions. Then I want to talk about what led up to the Shelby County decision. Why, after nearly 50 years of litigation under these provisions, did the Supreme Court think, you know what, these are unconstitutional? What led up to that pretty dramatic sea change? And finally, I want to talk about the impact of the decision and explore what, if anything, can be done to fill the vacuum created by the court's decision in this case. And after that, we'll have some Q&A. Does that sound good as a roadmap for how we're going to proceed? Okay. We're in a time now where we are reaching so many important milestones with regard to major civil rights activity and major civil rights legislation that unfolded in the 60s. All right, we just had this grand 50th commemoration of the March on Washington not that long ago. Next year, there'll be the 50th anniversary of the Brown versus Board, rather the 60th anniversary of the Brown versus Board decision. Similarly, next year, there'll be the 50th anniversary of the Civil Rights Act of 1964. A year later, in 2015, we'll have the 50th anniversary of the enactment of the Voting Rights Act. And then a few years down the line, in 2018, the 50th anniversary of the enactment of the Fair Housing Act. So we're just in this window now where we're seeing all of these opportunities to reflect on the impact that has emerged from really significant civil rights activity, civil rights legislative activity for the most part, that took place back in the 60s. And it's interesting that as we hit these milestones, we have an opportunity to talk about a particularly important case in the voting rights context. I want to take you back. Before we start talking about the implementation of the Voting Rights Act over the last 50 years, the Shelby County decision that invalidated key pieces of that legislation, I want to take you way back into the early 60s. Actually, I want to take you back to the mid-60s to a place called Dallas County, Alabama. According to the 1961 census produced for that county, the population for Dallas County was 57% African American, 5'7", but of the 15,000 African Americans in that county old enough to vote, 130 were registered, fewer than 1%. Early in the 1960s, local African American leaders formed what they called the Dallas County Voters League. And in 1963, representatives from that organization and organizers from the Student Nonviolent Coordinating Committee, known as SNCC, began to do voter registration work in Dallas County. They engaged in a number of efforts to enable the county's African Americans to vote, to register to vote, but county officials would consistently deny registration applications. On July 6, 1964, sort of inspired by a desire to make change here, John Lewis led 50 African Americans to the county courthouse on one of the 2 days per month that registration was permitted, but the county sheriff arrested them rather than have them register to vote. A few days later, a county judge issued an injunction forbidding the gathering of 3 or more people under the sponsorship of any civil rights organization. And so the injunction made it illegal to even talk to more than 2 people at a time about civil rights or voter registration in Selma, which is the county seat for Dallas County. Eventually, the Dallas County groups, the civil rights groups, the voting rights groups, they got frustrated and they looked for help. They enlisted the support of Dr. Martin Luther King, and together they developed a plan to march from Selma, Alabama, the Dallas County seat, to Montgomery, Alabama, the state capital, which is located about 50 miles away. The whole idea was that a bunch of marchers would make that trek and they would petition Governor George Wallace to sort of step in and work to ensure that their voting rights were protected. So on March 7th, 1965, 500 or 600 civil rights activists met in Selma and set out from Selma, heading east on US Route 80 toward Montgomery, Alabama. And when they were, where they intended, as I indicated, to press Governor George Wallace regarding his opposition to voting rights. But the marchers only got about 6 blocks when they came to the Edmund Pettus Bridge. When they tried to cross the bridge, they were encountered by a mass of state troopers and other law enforcement officials, many of them on horseback. They charged the marchers, beat the marchers, dispensed tear gas upon the marchers, and drove them to retreat back across the bridge back into Selma. The leader of the march, John Lewis, who, as many of you I'm sure know, later became a congressman, a U.S. congressman from the state of Georgia, is today a U.S. congressman from the state of Georgia, was severely beaten on the bridge, as were many others. 17 of the marchers had to be hospitalized. The violence and bloodshed on that day was so powerful that this day in the civil rights lexicon has been dubbed Bloody Sunday. And you can see John Lewis is actually the person in the front of the photo, as you can see being beaten in the picture that you've got. Well, did they ever make it to Selma? Eventually they did. It took 2 additional attempts. Dr. King organized a subsequent march. Eventually they did make it to Selma and arrived at the Capitol on March 24th. But what's interesting, all of that's interesting, but what's particularly interesting, especially in the current political context, when we think so much about gridlock in Washington, what's particularly interesting is that the images from Bloody Sunday were projected nationally by the news media March 7th, 1965. Those images that you've seen so shocked the national and presidential conscience that President Lyndon Johnson delivered an address to a joint session of Congress just over a week later. So March 15th, convenes a joint session. He gives a speech with regard to voting rights, and during that speech, pretty quick drafting, he presented a draft proposal for what would become the Voting Rights Act of 1965. So we have big splash, tragic event, March 7th, presidential address to a joint session, March 15th. That proposed legislation gets thrown into the congressional legislative mill, and amazingly, not only is that legislation quickly enacted, August 6th of 1965, not 1966, like August 6th of the same year, mere months after the president has proposed the Voting Rights Act, on August 6th, the president is signing the Voting Rights. August 6th it passed. August 15th, the president is signing the Voting Rights Act into law. And you think about our current climate, it's hard to imagine anything like this happening, but that was the power of the images, the power of the movements, and also the power of congressional frustration that I'll talk about in a minute. But before we talk about the Voting Rights Act itself, again, historical context I think is especially important here. I want to take you back even further. And I want to take you back into the 19th century. Because you might ask yourself, how is it that in this early 1960s period in Dallas County, Alabama, fewer than 1% of the eligible African Americans were registered to vote? Didn't we have a 15th Amendment that was ratified in 1870? We did, right? The 15th Amendment, ratified nearly 100 years before, 1870 again, to be exact, was intended to guarantee the right to vote, to protect the right to vote against abridgment on racial grounds. And that's what the 15th Amendment said. The 15th Amendment essentially laid out a promise that voting rights would be protected and not be denied on the basis of race or color. It was ratified just 5 years after the conclusion of the Civil War. And it really, there can be complicated constitutional provisions. This one's pretty simple. 2 sections. And the first section, it's the heart of the Voting Rights Amendment, the 15th Amendment. The right of citizens of the United States to vote shall not be abridged or denied by the United States or by any state on account of race, color, or previous condition of servitude. Right? So there's a guarantee, there's a promise that's embodied by Section 1 of the 15th Amendment. Section 2, again, relatively simple, it empowers the Congress to make good on this guarantee. Right? Section 2 says, we've got this guarantee of rights, but we also want to empower the Congress to enact appropriate legislation to enforce this guarantee. And that's the simplicity, a pretty clear, simple message that's represented by the 15th Amendment. Even though the 15th Amendment by its terms quite clearly prohibits efforts that would deny or abridge the right to vote on racial grounds, state and local governments, we know this history, particularly in southern states, continued to block African American access to the ballot box. Among other things, states and localities put in place special requirements that prospective African American voters had to satisfy, such as literacy tests, poll taxes, grandfather clauses, that excluded whites from the new special requirements that African Americans who wanted to register to vote had to satisfy. On many occasions, jurisdictions, the literacy tests that they would administer, they'd administer in multiple versions. The easier tests would go to prospective white voters, and the sort of really more difficult tests that most normal citizens wouldn't be expected to be able to pass would be handed out for African Americans to pass before they could register to vote. And there were other things. White primary races were conducted. Jurisdictions took all kinds of efforts to dilute the power of African American voters in these states. The bottom line point is that even though we had this constitutional amendment that was intended to protect voting rights, that established a promise of protection, states and localities were ingenious in the ways that they used to avoid, evade, and escape the requirements that emerged out of Section 1 of the 15th Amendment. And so even though there was a promise for nearly 100 years, the promise represented in Section 1 of the 15th Amendment was a broken promise. Congress got fed up. And so we see in 1957, 1960 finally, 1964, the Congress begins to act pursuant to the authority presented in Section 2 of the 15th Amendment. And in each of those years, 57, 60, and 64, Congress enacted legislation that it thought would help to make real the promise of the 15th Amendment, but it was ineffective legislation. It was legislation that authorized very piecemeal, case-by-case attempts or efforts to protect voting rights. And that kind of case-by-case litigation was slow, expensive, and even if you were successful in pursuing a court case that would lead to the invalidation of a particular voting practice, the jurisdiction would adopt a slightly different one that was outside the scope of the order that invalidated the previous voting practice. And so there was a clever evasion that was a part of this history taking place at this time as well. And so that's the context. And now jump from that period back to 1965, back to the point at which Lyndon Johnson delivers his speech and presents his proposed Voting Rights Act. And then what you see is a Congress that has been shocked by the horror of what we all, people who are old enough, saw on Bloody Sunday on their TVs, and frustrated by previous attempts to deal with this issue that have been totally ineffective. Right, you're a member of Congress. What, haven't we dealt with voting rights and this is still happening? Didn't we pass legislation in 57, 60, and just last year? but this is still going on, and look at what's going on, right? That's the vibe that you can imagine was present when the president says we've got to do something about this and we've got to do something about this quickly. And so it was a Congress that was in that mindset that acted to very quickly adopt the Voting Rights Act. So let's take a look at that 1965 legislation and what it was supposed to achieve. The key provisions in the Voting Rights Act of 1965 for our purposes, there are 3 of them. Section 2, Section 4, Section 5. Section 2, we're not going to spend a lot of time about, but it's the gut. In some ways, it's the core of the Voting Rights Act. Section 2 is like most civil rights statutes, right? It says in this area of life, no discrimination on account of race or color. And the area of life that Section 2 addresses is voting, right? So no discrimination, no denial or abridgment of the right to vote based on race or color. And this is a prohibition that is permanent, until some Congress acts to amend it or repeal it, and it's nationwide. I say that, it's sort of weird to say that, because most of the laws that Congress adopts, and all of the other civil rights laws that the Congress has adopted, they're permanent and they're nationwide. But that's something that you really have to make a point of when you're talking about the Voting Rights Act, because this Section 2 has that character. Permanent, nationwide, still alive and litigated and used frequently to protect rights of minority voters across the country. Section 4, and here's where we get to sort of the very interesting aspects of the Voting Rights Act that became the sort of focal point of the court in Shelby County. Section 4 establishes a coverage formula. And what this means is that Section 4 includes a test, we'll call it that, a formula, in quotes. It's not like a math formula, right? But it's a test or formula that's applied to determine which jurisdictions get put in this special category. And the whole idea behind Section 4, when the Voting Rights Act was enacted, you became a jurisdiction placed in this special category if you had in place a standard practice or prerequisite for voting. That is, you made people jump through some kind of hoop before they had to vote. If you had one of those in effect, then you could become subject to this special treatment. And if you had less than 50% of your voting age population registered to vote, or if less than 50% of your voting age population actually turned out to vote in the 1964 presidential election, right? So they just picked these criteria and they said, if you satisfy these criteria, you're gonna be in this special box. You're gonna be subject to special treatment. And that's what Section 4 did. It also suspended the use of devices and tests and prerequisites for voting in those jurisdictions that were subject to this special treatment. But beyond suspending those hoops in those jurisdictions, Section 4 did something else. It said the special category that you're in is jurisdictions that have to comply with Section 5. Right? And Section 5 is remarkable. Unlike Section 2, unlike typical civil rights law, which is permanent and nationwide, Section 5 was adopted as a temporary and regional, right? I say regional because you're only subject to Section 5 if you are captured by that formula in Section 4. So only some jurisdictions are subject to this special, this civil rights provision, and it was adopted to be in place for a temporary period. Section 5 was only supposed to operate as initially adopted for 5 years, right? And so that was that's the nature of how this was supposed to work. So let's talk about what this means. If you're a jurisdiction that's in this special category, if you're a jurisdiction subject to Section 5, if you're a so-called covered jurisdiction, and that's what we call it in the voting rights lexicon, you're a covered jurisdiction. If you're in that box, then any change with respect to voting that you want to enact cannot, shall not become effective unless you first get clearance from either the Attorney General of the United States or from a 3-judge panel that's based in Washington, right? So again, if you're covered, you can't adopt any changes that have anything to do with voting or elections unless the federal government or a federal court says, we think it's okay. You can go ahead and adopt that change. That's pretty powerful. If you submit your proposed change to the Attorney General under this law has 60 days to reject it or clear it. If the Attorney General does not act within 60 days of submission, then it becomes pre-cleared. The Justice Department had a whole section of lawyers in the Civil Rights Division who did Section 5 work. That's what they would do. A couple additional points about the workings of this pre-clearance process. One, you should know that the formula embodied in Section 4, you might imagine a couple of different ways that the Congress might have landed on that formula. The Congress could have said, okay, we're frustrated with these efforts to undercut and undermine voting rights. Let's think of a way we can craft a formula that could identify the jurisdictions that need special attention, right? Here's what we want to do. Let's think if we could, what do we want to have in this formula that will lead us to appropriately capture the jurisdictions that should get special scrutiny when they want to adopt voting changes. That's what they could have done. That's not what they did. Instead, the Congress was well aware of the history that I just recounted. The Congress knew very well which states, which jurisdictions were actively engaged in ingenious efforts to block African American access to the ballot. And so what they did was they said, we need to have a formula that covers Mississippi, Alabama, Georgia. They sort of, identified the states that they believed should be subject to this special scrutiny. Then they reverse engineered a formula that would take them to those states, right? That's how the formula was crafted, and that becomes kind of problematic in the Shelby County consideration. 6 states were originally covered by the application of Section 4 and thereby made subject to Section 5. Alabama, Georgia, Louisiana, Mississippi, South Carolina, and Virginia, right? Not all of the southern states, but a good, healthy chunk. Now think about what this means, because I keep saying that this is sort of a profound thing to have jurisdictions that have to pre-clear their stuff before they become effective. It is profound. When you think about our federalist structure, right? Some things the federal government does, some things state governments do, some roles and decisions, localities and states have authority to sort of proceed. Other areas, the federal government has authority. Sometimes there are clashes about that, but the idea that a locality or state has to get pre-approval, that's pretty remarkable. Imagine, Kansas has never been subject to pre-clearance. So if the Riley County Commission tomorrow or 10 years ago decided there have been some population shifts in Riley County, so the lines that we use to carve up our county commission districts, we're going to shift those lines a little bit to ensure that we still have the kind of representation from each of the county commission districts that's appropriate. Raleigh County Commission makes that decision. Maybe there's some public input. People don't like it, they complain. If somebody doesn't like it after the fact, they sue. But Raleigh County doesn't have to submit that to anybody to get pre-approval. Imagine instead that if we're not talking about Raleigh County, Kansas, but Dothan, Alabama, that instead their city commission decides, we don't like the way our district lines have been drawn for electing city commissioners. We want to adjust those lines for population shifts. In other words, that Alabama City Commission could be motivated by the same motivations that the Riley County Commission was motivated by, but that Alabama County, that Alabama City, that Dothan City Commission, they can't make that change effective unless DOJ signs off or unless a 3-judge panel signs off. Again, I think it's a pretty remarkable piece of legislation and powerful. And again, operated for almost 50 years in that fashion. Whether you're a proponent of Section 5, and I am, or not, you have to acknowledge it's intrusive, right? And the question is whether it's justifiably intrusive. That's what the debate's about. But it's an intrusive mechanism that emerges out of the Voting Rights Act of 1965. And once a jurisdiction submitted their change to DOJ, the standard that DOJ would use, again, let's go back to my hypothetical Alabama City Commission. They want to change boundaries. They submit that proposal to the Department of Justice. The standard that the Attorney General would use, or that the three-judge panel would use if they went that route, would be, does this proposed change have a retrogressive, nice legal term, retrogressive effect? In other words, imagine the capacity of minority voters to elect the candidates of their choice in the current system. Now imagine that in the proposed system. Has the capacity of minority voters been reduced as a result of this change? If so, then the change is rejected. If not, then the change is cleared. Okay. This whole process of pre-clearance shifts the balance. Remember, in case-by-case litigation, somebody who wants to challenge some voting decision that's been made by a jurisdiction has to show that there's something wrong with what this particular voting change accomplishes. This voting change has a negative impact that I'm going to use as the basis for my lawsuit. In these pre-clearance cases, the burden is on the proposing jurisdiction to convince DOJ or the three-judge panel that this change will not have a retrogressive effect. So the whole burden carrying responsibilities have been shifted as a result of operation under Section 5. One last point, a technical point about how this was intended to operate. Another thing that was included in the pre-clearance process was a bailout procedure. I told you that the formula was used to determine who would be subject to Section 5. There was also a provision that said if you are, once you're subject to this pre-clearance process, if you're like a good actor when it comes to voting rights for like a decade, you haven't proposed any changes that are retrogressive, you haven't lost any voting rights litigation, you've been really good as a jurisdiction when it comes to protecting voting rights. If you can demonstrate a clean record for 10 years, then you can bail out. You have the opportunity to petition and bail out of those special rules and out of that special treatment. Okay, once this legislation is adopted in 1965, as you can imagine, it's immediately challenged, particularly from the southern states that are subject to these pre-clearance rules. And the case that, important case, is this one, Katzenbach versus South Carolina, 1966 case, where the Supreme Court upheld the Voting Rights Act of 1965. The key fighting issue in the Katzenbach case was the controversy around Section 5. Because it's so intrusive, because it prompted the court to have concerns about the federalist structure of our governmental system. But the court ultimately concluded that it was a logical step. The adoption of this pre-clearance process was a logical step for the Congress to take because the Congress had enough. The Congress had tried less intrusive mechanisms in 1957, 1960, 1964 with its previous attempts to adopt voting rights legislation, and they had been ineffective. And so given the frustration in the Congress, given the ineffectiveness of less robust practices and procedures, the court was willing to say that this is an uncommon and maybe otherwise inappropriate step to take, but it's justified based on the exceptional and unique conditions that the Congress faced as it tried to tackle this issue through this voting rights legislation. So the Congress, the Supreme Court upholds this legislation. Importantly though, that this was supposed to be just 5 years, that it was so temporary, that was also an important part of the court's consideration when it said in Katzenbach that Section 5 should be allowed to stand. Well, as you can see, 5 years has become a much longer period. At the end of the first 5-year period in 1970, the Congress enacted an extension of these special provisions of the Voting Rights Act. an extension that took the act to 1975. When that 5-year period reached its end, the Congress acted again to put a 7-year extension on these special rules. And when that 7-year period was about to expire in 1982, the Congress adopted a 25-year extension for the life of these special rules. One side note that's particularly interesting, I think, given that where we are, we're in Kansas. Senator Bob Dole, by the way, played a critical role in crafting the language that enabled the 1982 voting rights extension and other amendments to the Voting Rights Act to pass. The Dole Compromise was the thing that enabled that legislation to make it through the Congress, and so there's a Kansas connection to that 1982 extension of the Voting Rights Act that, again, extended these special rules for another 25 years. When that 25-year period was about to expire, a year before that period was about to expire, the Congress extended the life of these special rules for yet another 25 years in 2006. And so under the law that existed by the time the Shelby County Court rendered its decision, these special rules were intended to remain in place until 2031. Was it controversial to establish these rules? Was there a catfight in the Congress to extend these special rules? No. When the Voting Rights Act was first enacted, I guess it was a little bit closer. In 1965, passage of the Voting Rights Act was, as you see, 328 to 78. In the Senate, 79 to 18, a filibuster-proof supermajority. And extensions, those ones that I listed, passed by overwhelming votes as well. The most recent extension in 2006, and this is the extension that the court was considering in Shelby County, look at those numbers. House passage 390 to 33 and unanimous passage in the Senate. So very strong congressional support for the act as originally adopted, and I don't know that you could describe the 2006 vote as anything other than overwhelming. Overwhelming congressional support for extension of these special rules another 25 years. And not only was the vote overwhelming, the record before the Congress that acted in 2006 was, to say the least, and this is understatement, voluminous. Thousands and thousands of pages of studies, records of hearings conducted across the country, particularly in the covered jurisdictions. The Congress was aimed at trying to get a sense of, okay, we're about to reach the end of another extension. We're thinking about extending it even further. We need to make a judgment about how much we want to extend it, if we do extend it. How big is the problem still? How much do we still need Section 5? Is there any continuing need to have these special rules? And so these hearings were conducted and this information was gathered by the Congress, all out of a desire to be able to answer those questions. They considered all of that data, and you see how they answered the question. Overwhelming support for another 25-year extension. So the political support in the Congress has been pretty robust, to say the least, particularly most recently. Well, who's subject to these special rules? I mentioned that originally Alabama, the states that I mentioned originally were covered, but as the Section 4 and 5 have been extended, other states have been brought within the ambit of the coverage formula, and it's because as the Congress extended the duration for application of the special rules, they actually said, if you satisfy this criteria for the 1964 election, that's what the original act said, then you're covered. When they extended it, they said, and if you satisfy this criteria for the 1968 election, then you're covered, in addition to who's covered by the earlier formula. And then they said, if you're covered by if you satisfy the standards laid out here based on performance in the 1972 election, you're covered as well. So the original states remained covered, and then additional states got brought in as that coverage formula was sort of extended in time forward, right? And so that's how additional states have been added. In addition, during one of the extensions, they amended the Voting Rights Act to also capture states that had issues with regard to participation of language minorities. And so that's why Arizona is covered, for example. So a significant Hispanic, Spanish-speaking population, bad registration and turnout numbers with regard to that population that show up in this formula, and the result is that Arizona ends up as a covered jurisdiction. There are 9 states that are fully covered, so up from the 6 original. And in addition to those 9, there are 7 states that are partially covered. That is, there are counties within these jurisdictions that satisfy the coverage formula. And these counties are all over the place. There are California counties, Florida, Michigan, New Hampshire, New York, North Carolina, South Dakota, and its native reservation land in South Dakota that triggers the workings of the formula that make those jurisdictions covered. So you see a smattering of jurisdictions across the country, but still the concentration for the coverage is still the states in the deep South. So this is the lay of the land, what I've just recounted, that exists. Jurisdictions are submitting their stuff pursuant to those pre-clearance rules that I've talked about. There are all kinds of issues being litigated that are important with regard to Section 5, but the train essentially is moving down the track, generally as I've described it, and that happens for years. And it continues to sort of roll out that way until a 2009 Supreme Court decision called Northwest Austin Municipal Utilities District Number 1 versus Holder. Northwest Austin Municipal Utilities District Number 1 sort of turns out to be the most awkward acronym that you can imagine, NAMUDNO. Some people actually refer to the case that way. I won't. I'll call it Northwest Austin. Northwest Austin essentially represented what I call a shot across the bow. And this was really a case, or at least fundamentally a case, about a bailout provision. I told you about the bailout provision. If you're a good actor for 10 years, you could seek to bail out. Texas is a covered jurisdiction. What this utility district wanted to argue is Texas maybe has not been a good actor sufficient to bail out, but our little utility district has been. Everything that relates to voting that we have control of in our district, we've done really well for the last 10 years. And we have some control of some voting stuff, and we've done really well. We haven't transgressed at all. You should let us bail out, even if the rest of Texas has to stay in. Well, there was some legal question about whether an entity such as this utilities district had the capacity to bail out under the voting rights law, under the act. I mean, can something like this take advantage of the bailout provision? So that was their argument. They had been denied that opportunity, and they were going ultimately to the Supreme Court to say that we should be entitled to bail out if we satisfy the criteria. And if you say we can't, then Section 5 is unconstitutional, right? That's the argument that they made. And so they go to the Supreme Court, they make that argument. Supreme Court, you know what? You're right. An entity like you should be allowed to bail out. So you can. You go back to the lower court, go back to the original place where you start that process. If you satisfy the criteria, you should be allowed to bail out of coverage. You should be allowed to bail out of the requirement to comply with all those pre-clearance standards. Case should have been done, right? An argument was made, the court accepted the argument, they win the case, we're done. We don't have to reach the question of Section 5's constitutionality, because that was an in the alternative argument. If you say we can't bail out, we say Section 5 is unconstitutional. Well, the court said you can bail out, but the court said, okay, we don't have a need to address the constitutionality of Section 5 because we've already resolved the case on these other grounds, but we've got some concerns about Section 5, right? So even though this analysis was not at all necessary to resolve, it was totally unnecessary to resolve the case has already been resolved. The court decided, let's express our concerns about Section 5, and they raised a number of concerns. A key reality with regard to the court's decision to raise these concerns, however, is that it wasn't just the so-called conservative justices that signed on to the opinion that articulated these concerns. It was an 8-1 decision with a majority opinion and one dissent. The dissent was from Justice Thomas, who wanted to reach the Section 5 issue and declare Section 5 unconstitutional. The other 8 just offered their concerns about Section 5. Justice Thomas was a dissenting in part, concurring in part. He concurred with the that these folks ought to be allowed to bail out, but he dissented from the refusal of the majority to actually address the constitutional question on Section 5. The rest of the 8 of them raised these concerns, and all 8, liberal, conservative, the whole shebang, except for Thomas, who had even stronger concerns than the ones raised by these 8, laid out their concerns. They all joined the chorus. And well, what are these concerns? What were these concerns? And to put it in a nutshell, change circumstances. Change circumstances. Now here's what the court had to say. Look at the South now. Look at the country now. Look at the dramatic increase in minority voter registration in covered jurisdictions. Look at the dramatic minority voter turnout increases in covered jurisdictions. Look at the sea change in these covered jurisdictions regarding the election, not voting by minority voters, but the election of minority candidates. Look at these southern state legislatures. Lots of African Americans represented in those halls, in those chambers. Look at the shift, or at least slight reduction, in the number of objections that the Justice Department is raising when jurisdictions submit proposals for preclearance. And look at the White House. African American president. This is in there. These are the concerns that are articulated in this Northwest Austin case. And for the court, even though it didn't address the issue, the question that emerged for the 8 who signed on to this opinion in Northwest Austin, the question that emerged is, there we see the things that I've just talked about. Conditions have changed, disparities have been reduced, minority candidates are successful, and for the court that raised some questions. Given these changed circumstances, are the burdens that Section 5 preclearance imposes on our federalism system, are they justified by any current need? We know that they were justified in 1965. The Katzenbach court told us that. And look at those circumstances. Those circumstances are radically different now. Is there a continuing need for these special rules? And second, whether you become subject to these special rules depends on this formula. Does the formula that produces the geographic coverage that we get for submission under Section 5, does it sufficiently relate to the problems that Section 5 preclearance are aimed at attacking, right? And so they threw those questions out there, didn't decide anything, and just said, just want to let you all know, we've got these concerns about whether a provision that was deemed constitutional in 1966 has been in place now for 40 years, whether it can continue to be justified on constitutional grounds in light of how circumstances in these jurisdictions have changed so profoundly. That was the court's view. All right. A few jurisdictions, right? You can imagine that decision sent signals. One maybe theoretical target for the signal was the Congress. Many speculate that this was the court rather, telling the Congress, you guys need to fix this thing before we have to decide a case that deals directly with the constitutionality of Section 5. We're telling you what our concerns are in a case where we don't have to decide the question, so that you'll have an opportunity to repair these tears, these breaks, before we're presented with a case that really has to decide the issue, right? That's one theory. Clearly, the Congress, whether they were listening or not, the Congress did not act in the wake of Northwest Austin, but other people did, covered jurisdictions did. They said, aha, Supreme Court's got some problems with this process, we're gonna take it on. And there were just a series of cases in the wake of Northwest Austin aimed at challenging the preclearance process. Arizona filed a case, Florida filed a case, Georgia filed a case, North Carolina filed a case, and the case that made it to the Supreme Court is Shelby County versus Holder out of Alabama. And this is a case in which an Alabama county filed a suit directly taking up the invitation that seemed to be put on the table by the Supreme Court, and argued that the federalism costs imposed by Section 5, imposed by this preclearance process, could only be justified by a kind of unremitting, ingenious defiance, which, while present in 1965, was no longer present in 2012 or 2013. The circumstances that justified this intrusive remedy in 1965 are no longer present, therefore this intrusive remedy is no longer justified. And the county also argued that the formula used to capture people for Section 5 coverage was obsolete. We have argument, and ultimately we have announced on June 25th a 5-4 decision that broke along predictable lines. On the side of those invalidating the decision, or rather invalidating Section 5 and the preclearance process, Roberts, Scalia, Kennedy, Alito, and Thomas. And then we have Ginsburg, Breyer, Sotomayor, and Kagan, who would have held the preclearance process constitutional even in light of the changed circumstances that have emerged in these jurisdictions. The court concluded that it's the formula that was unconstitutional. And it offered no view about the preclearance process itself, the submission of proposed rules to this process for preclearance. The reality is that if there's no Section 4, Section 5 is meaningless, because Section 5 only kicks in and applies to entities that have been identified by Section 4. If you knock out the mechanism that identifies the entities, then there's nobody there to go through the Section 5 process. So it's a technicality. It's an important technicality, but it's a technicality nonetheless. On the one side of this debate, you had dissenters who contended that there is a continuing need for a preclearance process like Section 5. If you look at the number of DOJ objections, maybe there had been a slight decline in the last couple of years, but actually there were more DOJ objections. That is, jurisdiction submits proposed change, jurisdiction says nope, DOJ says no, we're not going to approve it, go back and revise it or forget about it. There were more rejections during the last period of Section 5's operation, from 1982 to 2006, more than 700 objections. There were more during that period than there were during 1982 to 2004. There were only 626 in that window. And actually, if you go all the way back 1965 to 1982, only 490 objections. So DOJ has continued to find problems, even in this very current period, with proposals submitted by jurisdictions covered by Section 5, and the dissenters, those who wanted to keep this process in place, thought that was significant. DOJ asks frequently for more information. So that was another factor they thought was important. The proponents of the process also recognize that Section 2 litigation is disproportionately successful in covered jurisdictions. Another indicator that these jurisdictions have been singled out for special rules happen to be places which seem to be more susceptible to activity that makes them liable for voting rights violations. So even if you leave aside the special rules, they're more likely to be found liable in Section 2 litigation. The dissenters believe that suggests that this formula and this process is aimed at the right folks. It's aimed at the right jurisdictions. So they had these other factors that they thought were really important. And they also were quite persuaded by the point I made earlier, overwhelming support in Congress, very voluminous record developed by the Congress as a part of making that judgment. On the majority side, while the dissenters, those who would continue to have these practices in place, believe that there was a continuing need for these special rules, on the other side of the equation were those who carried the day based on their consensus or their belief that there's really a significantly diminished need for these special rules in the current environment. And we I talked about some of those. They really tracked with what had been pointed to as concerns in the Northwest Austin case. Significant increase in minority registration and turnout, dramatic success increase for minority candidates, and in fact, the blatant discriminatory objections in place when Section 5 was initially put into law, those have been outlawed now for more than 40 years, right? Poll taxes, special literacy tests. None of these jurisdictions have been doing this for a long time, right? So the circumstances, again, have changed so much that this group of justices believed that the very powerful and extraordinary tool of preclearance had sort of lived its useful life, but it was time to put it away. The other part of the question as posed by the court in Northwest Austin that then becomes a focal point of analysis in Shelby County is the actual formula itself. Does it really take you to the right places? Does it identify the appropriate jurisdictions? The proponents of the process said yes, it does. Covered jurisdictions, for example, represent just 25% of the national population, but 56% of successful Section 2 litigation. Again, these are places where voting rights legislation seems to be successful. So perhaps the proponents would say the formula is accurately identifying jurisdictions because of their voting practices should be subject to special scrutiny, and even if the activity is not as blatant or as brazen as it was in 1965, there's still an identifiable difference with regard to what happens in these places that makes it appropriate to subject them to special scrutiny when they want to adopt voting rules. And the bottom line was, look, for the proponents, the formula has worked. And everybody, all sides of this case, talk about how successful Section 5 and Section 4 have been. Nobody disputed that. The folks that wanted to say it's now unconstitutional, the folks that wanted to preserve it, they all said it's been successful. The real dispute was, on the one hand, you have folks saying this is an extraordinary measure that has worked, past tense, end it, move on. On the other side of the equation, you had folks that say this is an extraordinary measure that is working and has more work to do. And that's where these folks were when it comes to that sort of dichotomy. On the other side, those who wanted to invalidate Section 5, they thought there was a geographic disconnect, that the tool used to identify the jurisdictions that should be subject to special scrutiny wasn't a tool that connected to the current reality that needed to be addressed on the ground around the country. They thought that the formula, again, is a formula adopted in 1965, not really updated at all since it was adjusted to deal with data coming from 1972. So even the most recent data in this formula is more recent than 1972. And that's the formula that we're using to decide who gets this special, more onerous treatment, has to be subject to these more onerous procedures. And the court majority just thought it was inappropriate for the Congress to be basing special treatment for these jurisdictions on a formula that was driven by decades-old data. For the majority, that meant that the formula was ignoring and not taking into account the changed conditions that had occurred. States should be singled out for this kind of special onerous set of burdens only if their behavior is justified by currently identifiable conditions. That was the thrust of the majority view as it came to considering the formula. And they also said, we warned you, Northwest Austin, they raised these concerns. The Congress failed to go back and tinker with the statute at all, and this was a part of what the result of that failure turned out to be. So as I wrap up here, what's the bottom line and impact of this really important Supreme Court decision? Well, first, it invalidates the concept of covered jurisdictions. After Shelby County, there's no such thing as a covered jurisdiction under the Voting Rights Act anymore. That's done. Well, what's the big deal for that? Well, the big deal from that is that nobody is now subject to the preclearance process. no jurisdiction has to submit their changes to either the Justice Department or a 3-judge panel in order to have them determined to be appropriate with regard to the protection of voting rights. Texas, for example, had earlier, well before Shelby County, within a year or two before the case, adopted a voter ID law. Texas is a covered jurisdiction. So in Kansas, we can adopt voter ID laws and it will stand until somebody brings a suit against it. In Texas, because it's a covered jurisdiction, formally a covered jurisdiction, they had to submit their proposed voter ID law to DOJ for preclearance. Well, they decided they didn't want to go to DOJ. They went to a 3-judge panel. DOJ had problems with it. It was rejected. It was rejected under Section 5 as an attempt that would have reduced access in a meaningful way to the ballot in Texas on account of race and color. So there was an objection raised to that voter ID law in Texas, making it ineffective. Well, right after Shelby County was announced, Texas announced that it intends to reenact this voter ID provision. Since there's no such thing as a covered jurisdiction anymore, that provision doesn't have to be subjected to preclearance. It will become law and will stand unless somebody in Texas decides they want to litigate against it and challenge it. And so this has on the ground almost immediate effects in jurisdictions that had previously been affected by Section 5. And the bottom line is that DOJ loses a remarkably powerful tool to prevent the enforcement or enactment of voting rules, of voting statutes that would adversely affect minority voting rights. Well, what's next? Section 2 is still available, right? I mentioned Section 2 is national and permanent. Anybody who thinks that some proposed voting rights, well, not even proposed, some enacted voting rights provision affects their rights, undermines their voting rights on account of race or color, has the opportunity to pursue a Section 2 case-by-case piece of litigation to challenge that particular change that's been adopted. Not the same as Section 5, after the fact, piece by piece, case by case, more expensive, much more slow, but it's a tool that's still available. I expect that the Justice Department will expand its capacity to bring Section 2 claims, because the Section 5 section doesn't have anything to do now. So Section 5 has been invalidated. There's the preclearance section now has to find another line of work, and my expectation is that the Justice Department might beef up the Section 2 part of its voting section and just be more attuned to enacted provisions that threaten voting rights. Second, state constitutional proceedings. There's been voting rights legislation adopted in 2 states at least that has subsequently been invalidated by state Supreme Courts interpreting the voting provisions of their state constitutions. A Missouri voter ID law was invalidated on those grounds, and a voter ID law in Wisconsin was invalidated on those grounds. Will other states now follow that lead and look to their own state constitutions rather than to federal law or the federal constitution as a basis for scrutinizing some of these voting provisions? We'll see. It's an avenue that, at least in a couple states, has been productive for those who want to challenge these provisions. The third alternative that might be next, and we've already seen the Attorney General indicate that he will pursue this avenue, is little known, little used Section 3 of the Voting Rights Act. Section 3 includes what's called a bail-in provision. Now, under Section 3, if the Attorney General believes that a state or jurisdiction has been engaged in an intentional effort to undermine minority voting rights, then the Attorney General can petition a federal court to bail that jurisdiction into preclearance requirements, right? You know, bail out, I've been such a good actor, let me out of coverage. Bail in is, I'm not subject to coverage, the formula doesn't get me, but DOJ says I've been such a bad actor that the court is going to throw me into the preclearance process. And on the heels of the Shelby County decision, Eric Holder announced that he intends to look carefully at that provision and to breathe life into it, and in fact intends to use that provision to seek bail in for Texas. And he announced that just within the week or so following the decision. And so now there are a bunch of scholars and others looking at the viability of Section 3 as a sort of fallback now that the preclearance process under Sections 4 and 5 has been invalidated. And then finally, Congress could act, right? we have legislation that was enacted to advance the promise of voting rights. The Supreme Court has now determined that the statute intended to guarantee that promise, that statute is itself constitutionally broken. And so the ball is in the Congress's court. If it wants to take it up, the Congress could revisit the Voting Rights Act, take into account the concerns that the Supreme Court articulated in Shelby County, and then amend the coverage formula and other aspects of sections 4 and 5 to address the concerns that the court has articulated. That is an alternative as well. Immediately on the heels of Shelby County, I thought there was no way that was going to happen. But then within the few days later, I know that there are congressional Democrats, led largely by John Lewis, who clearly wants to see the Voting Rights Act repaired in the wake of this decision, who have an interest in responding to this decision. And then I also heard, just in commentary and through interviews, Bill Sensenbrenner, who was a congressman, Republican congressman from Wisconsin, who was very involved in the 2006 extension of the Voting Rights Act. He said he wants to revisit this and produce a section 4 or 5, a version thereof, that would satisfy court scrutiny. And in addition to Sensenbrenner, I've heard a few interviews with House Majority Leader Cantor, Republican congressman from Virginia, who says that he's interested in a bipartisan effort to try to address the concerns that the court outlined in Shelby County. Interestingly, what Representative Cantor said is that when he had an opportunity to go to one of the recent commemorations of the march that originally took place in 1965, John Lewis invited him to be a part of the commemoration, and he spent that time walking across the bridge with John Lewis, talking to people who were part of that story, who experienced that horrible day. And Cantor said that being there with John Lewis gave him an appreciation for the event, for that tragedy that he'd never had before, and it also gave him a new insight into the importance of this voting rights legislation, particularly as it relates to these jurisdictions. And so he said he came away from that experience with a new appreciation for how important this provision is, and that gives him a serious motivation, he said, to find others to work with to try to repair the situation that the Supreme Court has identified as problematic. In 1870, we had a promise of voting rights laid out through the 15th Amendment. We had that promise broken for nearly 100 years, actually nearly 100 years, before the Congress acted in 1965. The Congress sought through that really paramount voting rights legislation to make good on the promise of the 15th Amendment through the Voting Rights Act of 1965, and it recommitted to making good on that promise in 1970, 1975, 1982, and 2006. And here we are in 2013. The Supreme Court has determined that the tool that the Congress has used to make the promise of voting rights real is itself constitutionally broken. We've seen that there are alternatives that can be taken to repair what has been identified as broken. It's been my pleasure to share some thoughts and perspectives with you about what I think is a really important and interesting area of American law. I appreciate that you are here and that you have remained with me throughout the duration of this talk. Thank you very much for your attention and your presence, and hopefully you'll have questions that I look forward to responding to as well. So thank you very much. I really appreciate it. Time to take a break.
So thank you again very much,
My pleasure.
Robinson, for your insights tonight. So we invite you to visit the refreshments table over here on this side of the ballroom, and then we'll be sending around cards. If you have a question about the Voting Rights Act or Professor Robinson's presentation, we'll collect those questions and pose those to him. So please enjoy some refreshments.